Mr. Humphreys, yes.
My Lord, I'd been dealing with various concepts between, in relation to what I've characterised for the purpose of the written case as the two stages. And in relation to the first is the planning provisions and the cancellation assumptions, the final points I just make are these, that it's clear that the upper tribunal itself in this case applied first the cancellation assumptions in the way that I have described. So in the upper tribunal decision, core documents tab 9, page 153.
Yep. Yes.
You can see from paragraph 41 at the bottom of the page, the tribunal there, starting with section 16.7, which it says enshrines what's been called the cancellation assumption, goes on to talk about Fletcher Estates, makes the point that Fletcher Estates left open the question of how much of the scheme was assumed to be cancelled. Paragraph 42 goes on to indicate that Thomas Newell provided the answer to that, which very much accords with the submissions that I've made to you. Paragraph 43, Land Chamber rejected that argument, distinguished Fletcher Estates as being linear transport projects in dealing with the statutory assumptions to be derived, and a quote there which is in my written case. It's the point that section 16.7 talks about no part of the relevant land proposed to be acquired, and therefore the cancellation assumption only relates to the relevant land. Then goes on to say the Chamber did not consider that reliance on Point Gord entitled assumption to be made that the whole of the scheme was to be disregarded. Spiros gave no support for such a submission. Goes on again to quote from Newell there, very much in accordance with the submissions I've made to you, again, and set out all of this, which is why I'm summarising it in my written submissions. Paragraph 45 may be helpful to say something about Spiros. Talks about various points there, but just over halfway through, the conclusion of the House of Lords was that the Point Gord principle gave the lower courts no support for the proposition that the probability of permission should be treated as a certainty. Talks again, introduces a quote from Lord Collins at paragraph 129 of Spiros. The second part of that, the underlying basis for the decision in Waters is the extent of the scheme to be ignored for the purpose of valuation is not limited by the express provisions of Section 6. It does not go further and does not support the conclusions of the Court of Appeal. And that was, well, I don't need to elaborate that further. And they then came to the overall conclusion in 46. Claimants can fairly claim the support of paragraphs 24 to 31 of Newell in support of the submission that in the present case, regard is to be had to the acquiring authority's underlying KVP proposal at the stage of considering the planning assumptions to be made. Indeed, we do not think it is contested by the acquiring authorities, the point I was making before the break, that this was not controversial. We agree. The assumption required by section 16.7 must be taken as far but no further than its language warrants. It's also important not to elide the first
Stages are first identified.
the planning status, and then, which is where I get the language of planning status, and then seeking to value on that basis, applying the disregards to the result. So the tribunal itself accepted that that is the way that the cancellation assumption should operate. And it's clear from that, because it's quoting from Thomas Newell, that Thomas Newell, again in the tribunal, adopted exactly the same approach which I've identified as correct, and Thomas Newell itself refers to an earlier decision called Urban Splash, which again identifies and uses exactly the same principle. So the principle that in looking at the prospect of development with regard to section 14.3, that one applies the cancellation assumption is not a creation of my mind. It's what the tribunal applies, and what the tribunal in this case clearly thought appropriate. The Court of Appeal on this, just for the record on this particular point, which is page 134 of that bundle.
Yes.
8, paragraph 33. It says, this is essentially a dispute about the methodology necessary to implement section 6.1. I accept Mr. Humphreys' submission, as did the upper tribunal, that the planning status of the reference land and the prospect of some other permission being granted, hope value, are both matters for the first stage, which, even taking into account the cancellation assumption under section 16.7, should conform as far as possible to reality. The planning permissions, if not already granted, are assumed on the basis of the actual development plan and the policies then in existence. The cancellation assumption may in some other cases require the upper tribunal to assume the cancellation of the development project, but this is not one of those cases. In other words, again, one just cancels what is on the reference land itself.
Yes.
And in my submissions, I won't go through it in detail, but if you were to look at the written case in the bundle from pages 82 through, I think, to 90, I have my heading at stage 1, the planning provisions and the cancellation assumption, which sets out a lot of, and draws together those quotations and charts really the evolution of the cancellation assumption from Fletcher Estates through to its application in relation to section 14.3. So that, as I say, I believe is not controversial, certainly as regards the tribunal and the Court of Appeal, and indeed as recorded there vis-à-vis the appellants themselves. Now, as far as the disregards are concerned, and I start dealing with the valuation disregards, as I've collectively called both the statutory and the non-statutory disregards, statutory disregards being section 6 in particular in this case, non-statutory being the point called principle, it is important to have in mind what is to be disregarded. And perhaps here it's best if we go and look at the provision itself. So it's the authorities, tab 1. And page 387.
Yeah.
And the wording there, obviously, my Lord, one can read for oneself, but it's important to note that whereas throughout sections 14 to 17, the language used relates to planning permission, they are relating to planning permission. When one turns to section 6, there is no reference to planning permission. What is to be left out of account is value attributable to the carrying out or the prospect of so much of the development mentioned in relation thereto in the second column of the schedule as would not have been likely to have been carried out. You go down to the second bit of A, if the acquiring authority had not acquired and did not propose to acquire. In other words, although we talk about no scheme, what Section 6 actually tells you to leave out of account is value attributable to development that would not have been carried out but for the acquiring authority. And this provision and its relationship with the planning provisions, as I've called them, sections 14 to 17, those provisions started in the 1959 Act, which we have at tab 3. And in particular, it starts on page 422. The 1959 Act, and I'm not sure why it was different in the 61 Act, the provisions actually appeared in a slightly more logical order, in that the planning provisions appeared first and the valuation disregard provision, the equivalent of Section 6, appears at the end. So one goes through Section 2 in the 1959 Act is various assumptions as to planning permission. Section 3, assumptions not directly derived from development plans. Section 4, special assumptions, and so on. And eventually one comes to Section 9, it's on page 438. Section 9 actually is interesting. I mean, Section 6 in the 1961 Act is as your lordships will know, famous for being difficult to understand. Actually, strangely, Section 9 in the original Act, which it came from, is much easier to understand. And it's because in the 1961 Act, two parts of what is Section 9 here were put together. But what Section 9 starts with, so this is the predecessor of Section 6, is 9.1, in addition to the rules applicable in accordance with Section 2 of the 1919 Act, which prescribes rules for the assessment of compensation. Now, I don't need to take you to those, but you have them at tab 8, and those are what we now have in Section 5. So it's things like the open market value rule. So in what it's in sense saying here is, in addition to rules, including the open market value rule, the following provisions of this section shall have effect for purposes of assessing compensation payable in respect of compulsory acquisition, to which Section 1 of this Act applies. Now, it's clearer here, there's no equivalent of that in Section 6, it's clearer here, however, therefore, that Section 6 is very much tied to the rules of valuation. It's quite separate from the sections that have gone before, which were all about planning permission. And as I emphasised, the word planning permission doesn't appear in Section 9, or its later equivalent Section 6. And 9.2 says, in each of the cases mentioned in the first column of the following table, no account shall be taken of any increase or diminution in value of the relevant interest, which is attributable to the carrying out of such development as is mentioned in the second column, or the prospect of such development that it will or may be carried out, insofar as any such development is or would be development arising in the circumstances of that case. So what you leave out of account is carrying out of development or the prospect. That's the no scheme world. It's not that you invent another world or you rewrite planning. You leave out of account development. Now, if you compare that provision with Section 6, you will immediately say, but in Section 6 it talks about as would not have been likely to be carried out in any event. That provision appears in the original Act, 1959 Act, in subsection 7A. Reference in this section to development which is or would be development arising from the circumstances of a case mentioned in the first column, set out in subsection 2, in relation to the acquisition of land involving development of any of the land authorised to be acquired, shall be construed as a reference to development, whether actual or prospective, which would not have been carried out if the acquiring authority had not acquired and did not propose to acquire any of that land. And it's because actually that provision and what is 9.2 are combined in section 6 that section 6 becomes particularly difficult to understand. But the point I make, and it can be understood if one goes back to section 6, which is in tab 1, page 387, is what is left to be left out of it is development, the prospect of development that would not otherwise have come forward. Now, my respectful submission, there's nothing in that language about leaving out of account value attributable to development that entitles one to go back and change some assumption as to planning permission or change the prospects of planning permission. What's to be left out of account is the acquiring authority in the market carrying out its development evaluation effects of that. And in some senses, therefore,
how can you take account of the prospect of development without having some account of planning, since, development in this country requires planning permission, so...
yes, but
I don't quite understand the distinction you're trying to make.
It's the prospect, it's the carrying out of the prospect of so much of the development mentioned here too in the second column. And the second column, you have to find the schedule, which is later. It's on page 399. The second column, case 1, is development of any of the land authorised to be acquired, other than the relevant land, being development for any of the purposes for which any part of the first mentioned land is to be acquired. In other words, it's the authority's development for which it is...
It's the KBP scheme.
Yes. And...
So you can't take account of that.
Yes, unless that development would come forward in any event, in which case you can.
Okay.
And therefore...
But that inevitably involves some sort of implicit assumption about what would get permission or wouldn't get permission.
Well, my lord, I think that, with respect, is pushing the language too far. What is to be left out of account is value relating to the development or the prospect of development, not a rewriting of planning history. So, for example, the Nall refusal, difficult to see how one would have less regard or attach less weight to the Nall refusal because one had to disregard the fact that the acquiring authority scheme was not going to come forward because the acquiring authority scheme there wasn't even a compulsory purchase order at the time of the Nall refusal. It was refused on the policy grounds.
But that's a question for the tribunal, isn't it? I mean, you say that, but they clearly thought that the existence of the scheme was a factor.
My lord, it would be a matter for the tribunal if they had considered it on the correct basis. They clearly did not come to that conclusion, arrived at on the cancellation assumption, because on the cancellation assumption, the rest of the scheme goes forward, the planning policies are in place, and you go to the local authority and you say, look, there's this bit of the scheme which the acquiring authority and its development partner, Wilson Bowden Developments, don't now own, and the planning authorities say to you, well, you have planning permission, it's an extant planning permission to develop that part as part of the KBB scheme. Get on with it. Why on earth would we grant you planning permission for something else which allows you to go down Buckley Hill Lane. This is the important point. There was planning permission on the reference land, but it was planning permission as part of KBP. What we're talking about is the prospect that the planning authority, bearing in mind its own policies, would then completely ignore all of those policies, disregard the planning history, and grant consent for something else.
Well, the problem, the assumption that the scheme no longer operates in the reference land requires them to reconsider it, doesn't it? Because the original policies assumed that it was all going to be part of the scheme. Now, if you then jettison that assumption and assume that the scheme is not going to apply to the reference land, it then becomes a question of fact. What in that new situation would be the prospect of getting planning permission? Now, they have found, as a fact, what that prospect was. Why is that not the end of the matter?
My lord, because there you're assuming that the planning policy was in effect synonymous with the scheme. And as my learned friend said, it's not. The planning policy predated the scheme by 10 years.
That's not the assumption I'm making. I'm simply assuming, as the upper tribunal clearly did, that once the reference land is no longer going to be part of the scheme, which is the assumption that you have to make, a fresh view would have to be taken on whether to grant planning permission for its use in some other way. And they have concluded that there's a 50-50 chance that that would happen.
Yes, but our point is they should have done that on the cancellation assumption. In other words, cancelling the scheme on the reference land, and not by creating a no-scheme universe in which clearly, as one can see, led to a different result where they then awarded extra hope value.
Are you submitting that the upper tribunal had lost sight of the fact that they had to assume that the scheme was cancelled only in relation to the reference land?
Well, it's clear that yes, it's clear that that is what they did. I drew your lordship's attention to paragraph 117 earlier. Where they page 176, I do apologise.
Yes, 107.
As we've said in our conclusions on planning and the law, we do think that there would have been a 50-50 chance of planning permission being obtained on a reference land in a no-scheme KBP world.
Well, where do we find you're submitting that what they meant by a no KBP world is a no KBP world at all, rather than a no KBP on the reference land world?
Yes, and it's
they clearly did, but that's because they've got to section 6.
96, it makes it absolutely clear.
Yes, there's no...
But I mean, that's what they got to do, Mr. Humphrey. You see, the cancellation assumption, Fletcher Estates, is all about section 14 and section 16. Once you get on to section 6, you're having to ignore the KBP as a whole, because that's what it says, on land other than the reference land. And that's what they're doing. They're saying, we've got a bit of land which has hope value. It doesn't have the benefit of any permissions under section 16 for the reasons they set out. On the other hand, such hope value as it has is diminished by the policies which apply to the KBP scheme as a whole, and therefore, since we're required to disregard the prospect of that development, we give less weight to those policies. Yes. That's all they're saying, and that's a matter of judgment.
But the point there that the policies that relate to KBP as a whole, it's not that they related to KBP as a whole, they related to that area of land. And it was very clear in the policy in EC6, in the criteria, that insofar as there was separate. If I use the word independent, I'm not talking about access through the NIB, but just some separate independent form of development. It had to be developed as part of the comprehensive scheme.
That was a policy. And in paragraph 96, the tribunal will say, well, in the no KBP world, that would have less weight. They're not saying that you ignore the policy. They're just saying it would have less weight, and therefore there would be a better case for granting permission on the reference land.
Well, with that, it really then takes me to sort of try to consider on what basis they were able to apply a no KBP world. And my submission, Section 6 and Schedule 1 does not permit that. If I look at my own written case, the section dealing with this starts at paragraph 108, looks at the language of Section 6 and Schedule 1, and paragraph 111 makes 4 submissions. Say, to the extent that such an approach may have some, sorry, my lord, it's page 97.
Yeah.
To the extent that such an approach may have some initial attraction, it does not withstand scrutiny. There are a number of reasons why Section 6 cannot properly be extended to disregard planning policy. Discussed above, Section 6 is a provision related to value, relates essentially to the disregard of value attributed to the carrying out of the prospect of development that would not have been likely to be carried out. B, there's nothing in the wording of Section 6 that suggests it can be applied to review and revise any of the physical or other characteristics of the land, whether that be the interest to be acquired or the planning status of the land. C, there is nothing in the wording of Section 6 that suggests it can be allowed to, in effect, trump the planning provisions. There is nothing in the wording of Section 6 that gives it primacy over a conclusion reached about planning status under the planning provisions, nor are the planning provisions said to be subject to Section 6. And D, it's clear from a reading of Section 14 to 17 of the 1961 Act that whilst they are directed to the issue of planning permission, Section 6 and Schedule 1, together with Point Gord, are directed to the issue of development, not planning permission. One deals with the characteristic of the land, planning permission, or the prospect, and Stage 2 deals, in effect, with the market for that land with those characteristics. And if I return just a moment to my point C there, if Section 6 meant that one was allowed to go back and disregard a planning permission or attach less weight to a planning permission that in some way related to the scheme, that would do very considerable damage to Sections 14 to 17 themselves. Section 14.2, if we look at the authorities bundle, so it's the authorities bundle so tab 1, page 390, says any planning permission which is to be assumed in accordance, sorry.
Which subsection?
14.2. Any planning permission which is to be assumed in accordance with any of the provisions of these sections is in addition to any planning permission which may be in force at a date of service of the notice to treat. Now, typically in a compulsory purchase order, because it's a matter of policy to get compulsory purchase order, you have to demonstrate there is no planning impediment. You will either have planning permission for the scheme in place, or you will promote it at the same time. And therefore, in most cases, there will be planning permission for the scheme, and that may be very valuable to a landowner in many cases in a city regeneration
Depends what the scheme is. I mean, if it's
of course.
If it's a sewage works, it's not very valuable.
Absolutely, my lord, of course. That's why I say in many cases.
Can I take you back to paragraph 96 for a moment? I'm sorry to harp on about this point.
Of course.
And I may well have completely picked up the wrong end of the stick. As I understand it, what paragraph 96 is saying is that the reasons for the refusal of the earlier application were that it would get in the way of a comprehensive and properly funded scheme. Now, as I understand it, it would get in the way of a scheme of which the reference land was part. In a universe where the scheme does not include the reference land, you've got to reconsider what planning consent might be available for the reference land. Isn't that what 96 is saying?
My lord, but if one looks at the null refusal, one looks at the null refusal, which you have in Core Document Volume 2, Tab 14.
Right.
It's not refused because it would get in the way of some other development. The refusal grounds are, one, the site forms part of the Kingsway Business Park. That was the title in the planning policy, identified in the Council's Unitary Development Plan. The Kingsway Business Park represents the Council's primary opportunity to provide a strategic site offering a supply of large, well-located sites to near major modern industries to the borough into the foreseeable future. It's also an important part of the strategy, the economic regeneration and future competitiveness of the Northwest region. In order to achieve this primary objective for the business park, Policy EC6 of the Council's development plan sets out criteria which must be satisfied by any proposed development of the site. The proposed development fails to satisfy these criteria. The proposal takes access from Buckley Hill Lane.
We've read the document.
But
I apologise, sorry.
It's slightly different points being made to you, which is what they're saying in paragraph 96, what the tribunal is saying, not what the grounds of refusal were. I wonder whether you might say that in relation to paragraph 96, the reference to at the end of the anti-penultimate sentence to the absence of any active scheme for a business park might suggest that they were envisaging a complete absence of such a scheme.
The question that's being asked is whether no such scheme, line 4, means no business park at all, or no business park.
No comprehensive business park.
No business park which includes the reference land.
And I'm suggesting that the reference to any active scheme for a business park at the end of the anti-penultimate sentence suggests that it means any business park.
Yeah.
I think it does. That's
I mean, it's clearly.
But then we have Lord Carnworth's point. Section 6 plus.
But it's obvious that's what they're doing.
Yeah.
I mean, they've dealt with the cancellation assumption, which, for reasons known only to the draftsman, requires you to assume only the cancellation of the scheme over the reference line. They're now moving on to Section 6, which is broader and requires you to ignore any diminution relating to development on the other land. So that's why you get paragraph 94, the no KBP universe. And that's why they tell one in the end of paragraph 95 that you're considering a situation where there's no specific scheme just getting off the ground, because the CPO is ignored. You've got to look at the matter more broadly. And that's why when you get to 96, they say, we don't ignore the planning policies, but they carry less weight.
yes, but
I mean, as you know, with respect, it's fairly clear what they're doing. It's just that
if
they seem
that
to be
was-
trying to conflate what they're doing here with an exercise which is they've been
But
through.
my lord, if that approach was right, and I was looking at section 14.2, which was about actual planning permission, and I made the point that very often an actual planning permission can be very valuable, well, that too is a result of the scheme. It's planning permission for the scheme.
Mr. Humphreys, I mean, I've been through this. Section 14 and the succeeding sections are giving something to the landowner which he might not otherwise have. He gets the actual permission, even though he might not have had it in a no-scheme world. Now, that was a policy decision which was made by the draft.
Yes.
I don't know why. So that's simply dealing with permissions, which you assume.
Yes.
Now, Section 6 is dealing with a completely different thing. It's not completely different, but it's a quite separate conceptual stage, which you're asking about value.
Yes.
And you're doing exactly the same exercise you would do in Melwood or any of these places, is asking what value you've got, and that includes prospect of development. And to the extent that prospect of development implies permission, well, then obviously you have to deal with that. But it's a separate stage, and,
Yes.
and you're dealing here with improvement of value or diminution.
Yes. Well, I mean, in a sense, that's my point, that it is a separate stage. That's why I've called it stage 1 and stage 2.
But you seem to move from the idea there are two stages to saying they're completely sort of separated, which I don't understand. But anyway, that's what I've been going over for the
never
last
meant to say
couple of
that
hours,
they're separated. I've meant to say that there are 2 stages, and that's why I've called them stage 1 and stage 2. But the point I was making there is, to the extent that one allows the exercise of disregarding the carrying out of development or the prospect of development to allow you to revisit and revise the planning status of the land, then that would obviously render OTOs the provisions that say, well, you can take into account under Section 14.2 actual planning permission, or Section 15,
So why?
which says you can take into account...
Why? If you've got a provision which says you have the benefit of an actual permission, why does that detract from other provisions which say, well, you can take into account the prospect of development? I mean, they're not mutually inconsistent.
With respect, my Lord, I think they are. Because if I treat the prospect of planning permission, again, as something which has to be dealt with and identified in order to know what you are valuing, of course, it's not the same as an assumption as to an actual planning permission. It is a prospect. That's what Spiro's told us. But nevertheless, it is part of the characteristic of the land. It is part of what you are valuing. If it's appropriate to revise that by reference to Section 6 as suggested, then it's difficult to understand why that doesn't apply to some other planning permission which is assumed, or an actual planning permission. My Lord, so I've set out there as part of a wider set of submissions on why I say that the language of Section 6, which is about disregarding value attributable to the carrying out of the prospect of development, does not allow one to disregard parts of the actual planning history, or attach less weight to those, or to disregard or attach less weight to the actual planning policies. If one turns then to Point Gord, and I deal with this really from paragraph 116 in my written case, page 99, it's clear that from Waters that Point Gord now should be understood as working with, but if I may put it like this for shorthand, sort of subsidiary to Section 6. And if one turns in the decision of Waters in the House of Lords to tab 13, so this is the Legal Authorities Bundle 2, page 587. Lord Nichols here from the bottom of the previous page, where he's dealing with the Land Compensation Act in paragraph 48, starts in paragraph 49 to talk about the provision, the thrust of Section 6 and what that means. But at paragraph 51, 1, he identifies the first lacuna. He says the first most obvious oddity is it makes no provision regarding value attributable to the prospect of development of the subject land itself. And he ends that by saying planning permission is one thing, prospect of development is another. At the end of the next paragraph, 52, he says, accordingly, in these cases, point gourd should continue to be applied. In other words, it fills this particular lacuna. And at 53, he says, had the massa rested there, Section 6 might well have been open to the interpretation that in all other respects the new code was exhaustive, but there's at least one further gaping lacuna in the code, and that relates to where the acquiring authority has already acquired the land by agreement, which wouldn't fall within Section 6. And again, he says that cannot have been intended. Now, so those are identified, certainly at that stage, as the two ways in which point gourd can be used. And when at paragraph 63, page 589, Lord Nichols sets out his various pointers, paragraph 63, he says, when applied as a supplement to the Section 6 code, which will usually be the position, the point gourd principle should be applied by analogy with the provisions of the statutory code. Now, let's just consider that. My submission to you in relation to Section 6 is it's about disregarding a value attributable to development or prospect of development. It's not about rewriting planning history or disregarding or attaching less weight to planning policy. What Lord Nichols is making very clear here is point gourd only has two roles now that he had identified, certainly the two lacuna, paragraph 51, paragraph 53. And when you do apply it, you should apply it as a supplement to Section 6. So it doesn't anymore have some life of its own, which is why I say that looking back at Melwood is unsafe post these more recent cases, including Waters, because clearly the Privy Council in Melwood was not, having regard to these pointers, was not treating point gourd as a supplement to Section 6. And if point gourd there is a supplement, if it's applied in like way to Section 6, again, in my submission, it's difficult to see how it allows one to go back and alter the planning assumptions. And when one then looks at what Spiro's had to say
Can I
about...
just stop you a moment? I mean, I understand, but in this case, at paragraph 91, the tribunal said we don't need point gourd because actually the Section 6 and point gourd cover, on the facts of this case, cover exactly the same ground.
Yes.
Were they wrong on that?
Insofar as they were dealing with value, no. I think that they were right on that.
Yes.
My point was that, well, you don't...
I mean, your general point, I fully understand, is really that you can't revisit planning
Yes.
status at this stage. But that applies to
course.
point gourd or Section 6.
Right.
And in this case, we know that the tribunal treated them as being the same.
So my point is, when they got to, having gone through in the decision the planning stage and not having come to any real conclusion, one might have expected them to have come to a conclusion at the end of the planning stage where they say, well, planning assumptions, it starts on page 152 of the core document bundle. On the with the planning assumptions, and then they, at page 159, they look at evidence and submission on the planning assumptions. And they eventually come to a conclusion. Yes, it's on page 165, is where they, from paragraph 80 onwards, they consider consideration of the cancellation assumption. And they don't at that point come to a judgment that, look, on the cancellation assumption, the prospect of development is 40%, 45%, 50%, whatever. They simply come to a conclusion, paragraph 82, brief summary, our view of the planning assumptions to be made on the basis of the cancellation assumption is that the owner of the reference land would nourished expectation of some housing development on the reference land within a reasonable time.
Yes.
So there's no conclusion on the planning assumption. It's only when you get then to applying a no-scheme world, or a no-scheme universe as they sometimes call it, at the
Well, they give it a qualitative assessment in 82, don't they?
Yes, one can say there is a qualitative assessment, but it's clear, and this is my point, that they only come to their quantitative judgment when they've applied a no-scheme rule. So they have first applied a cancellation assumption, then they've applied a no-scheme universe assumption, and on the basis of the latter, paragraph 98, they say that there would have been some extra hope value of a permission for residential development. In other words, it's the application of the no-scheme world that is here the uplift. My Lord, in relation then to Spiros, I've made a number of submissions in various parts of my written submissions, but you can see, for example, from paragraph 116 onwards, that is not the only place, but there, in fact, the quotation from Your Lordship in Spiros at paragraph 55 and 56. And on page 100, I end by saying, I quote from you, I do not consider that it is right to invoke the point gourd principle or any other principle developed by the courts for the purposes of adding a wholly new assumption to the statutory assumptions which have been laid down by the legislature. And therefore, my point, it goes hand in hand with my Waters point, one can't or one shouldn't be using point gourd to in some way enhance Section 6. One can use it to fill the lacuna, and one can use it in the same way as Section 6, but it would be wrong to invent an additional principle here. Here, the principle being...
As far as the issue was whether assumed the planning permission had been granted, but it hadn't been.
My Lord, yes.
In this case, we're concerned with a completely different question, which is what prospect would there have been of getting planning permission at the relevant day on a no-scheme assumption?
Well, that's the point. I say one considers...
either helps you or...
I say that it's clear from those authorities and the way the tribunal and indeed the Court of Appeal approached it, indeed the tribunal in other cases approached it, that one considers the prospect of planning permission on the cancellation assumption.
Yes.
My point is...
Well, that's under Section 14. Section 16, it says so.
Yes.
But that's, I mean, this case was dealing with those questions. It wasn't dealing with Section 6.
No.
My Lord, yes, of course. I accept that entirely. I hope by taking you to this, I haven't sort of implied that this was precisely on all fours. What I'm doing is making the general point that one shouldn't use point gourd or indeed any other principle to in effect supplement Section 6. Section 6 needs to be looked at on its own terms. My Lord, on that basis, therefore, and I turn now to other arguments, but on that basis. We say, you can see from paragraph 100 in the written case, that that actually what led to the reduction in land value here was not the acquiring authority's scheme, but the planning policy, which was separate from the scheme. We would say there's no reason why someone in a particular case who happened to be subject to a policy and within a compulsory purchase order would be able to say, well, look, I can add less weight to those policy criteria because I have to assume that the scheme is cancelled, and yet someone immediately outside the boundary of the compulsory purchase order and the scheme, but subject to the same policy, would be told, well, sorry, look, these are the criteria in the policy, and you are subject to them. That leads to, my respectful submission, a sort of an inappropriate inequality between those within a scheme and without a scheme. And as I point out here, there will be many cases where planning policy enhances the value of land, but also cases where the planning policy reduces the value of land. But it's not the purpose of the compulsory purchase code to make good a restrictive planning policy. Restrictive planning policy is a matter for the local planning authority. And that is a sort of point I've developed there. In paragraph 101, I deal with the point that the result here is fair. It's not an unfair conclusion. This was a piece of backland. The developers, Bloor, purchased it in the hope of taking it out of the compulsory purchase order. They failed. They paid money for it, but they failed. And really, it's not for the public purse to compensate them for an unsuccessful failure. The planning policies were restrictive here, and it's wrong to apply a no-scheme world in order to, in some way, reduce the weight to be attached to those. Now, page 103, I turn to the alternative case, which is where I say, if I am wrong on all of these submissions, then we say that the Court of Appeal is right. And in essence, the difference between the Court of Appeal's approach and the upper tribunal's approach was that the tribunal allowed the appellants here to claim the benefit of certain aspects of policy, the fact that this site had been identified in plans for a number of years, but to attach less weight to the restrictions at those policies. And again, that done by reference to a no-scheme world. And in essence, you can see from paragraph 138 in my...
Page 107, yep.
Where...
You quote from Lord Justice Patton.
Exactly. And you can see there a number of quotations there, paragraph 140, 141, so on, my lord. I won't read them out, but the result of that is that we say if it is appropriate to revisit the planning assumption, the planning policy and the planning history, then that ought to be done in a comprehensive and consistent manner. It's not appropriate in those circumstances simply to go back and disregard certain aspects of planning history. If the scheme is affecting value and if that is tied up with policy and planning history, then really that exercise should be undertaken in a comprehensive and consistent manner. My Lord, the final point I'll mention is just this. I too had some short submissions from page 115 in the bundle on the effects of the Localism
Very helpful, thank you, yes.
Act. Can I just draw your attention to one paragraph where I've slightly over-compressed
Fine.
something, just so that you're aware of it. Paragraph 160.
Thank you.
I say the effect of the Act is to widen
Yes.
the effect of the cancellation assumption, and then I refer to the relevant land and relevant land. What it should say is the effect of the 2011 Act is to widen the land to which the planning assumption may apply,
Right.
from the relevant land to the relevant land and other land, and then I should draw attention separately to the cancellation assumption, which is section 14(5)(a).
That goes towards the bottom of the page, yep.
It goes.
Oh, no, I see, it's
Yes, I mean, I've missed that point out. I compressed two things
Yes, I see.
together, and I apologise for that. And
They're the two prongs to
there are two prongs.
Thank you.
And in paragraph 162,
Yep.
you will note there was a correction to this, but in the first line,
Yes.
that should be a reference to clause 27,
Thank you.
and the footnote 66 should be to tab 6. And again,
Don't worry. Very helpful to tell us. Thank you.
my Lord, unless I can help further, those are my submissions. Thank you.
Thank you very much indeed. Thank you, Mr. Humphreys. Mr. Booth.
My Lord, I have nothing to add to the submissions of Mr. Humphreys.
Thank you very much. Mr. Kingston.
My Lords, I think I've just got 3 points. There may be some sub-points, but 3 points. The first one is a matter of fact, which may be important in the light of the way my learned friend puts his case, and that is, as before, he laid emphasis on the null refusal.
Yes.
I told you that predated the compulsory purchase order. I don't think, with respect, that's right. Yeah, predated confirmation, yes. But yes, it's all right. It just needs to be clear.
It postdates the order, but predates the confirmation. Okay, thank you.
So it was very definitely in a scheme world that refusal was taking place. The second point is to go back to the point which I made earlier, and my learned friend really doesn't address. This tribunal was very careful to say, paragraphs 52 to 55, this is the nature of the exercise which we think, on the submissions and evidence we've heard, we have to undertake. They set it out for all to read, and so far as I'm aware, those paragraphs, that approach has not been subject to criticism in a way which would suggest, at the outset, that that they may be very experienced, maybe, in one respect, very learned, but these chaps got it wrong. And once the tribunal set that framework, you can see, and I resist the temptation to do what I was going to do this morning, because I don't think it's now necessary in the light of what your lordships have evidently read. Once they set that framework, they set a course which they faithfully adhered to. They dealt with the cancellation assumption universe as they described it, the paragraph 53 case, went through it, reached conclusions, paragraph 82 and then 84. They said in 84, but there's no point in us going any further with the cancellation universe case, because it's all going to have to be disregarded, because it depends on the scheme.
That is where it is said against you they went wrong.
Yeah.
Mr. Humphreys agrees, I think, that they've set out the framework correctly and purported to apply correctly. He says where they've gone wrong is applying the no scheme disregard to the prospects of planning permission and thus to hope value. That's where he says they've gone wrong. I mean, if he's right about that, then there is a fundamental error of law.
Well, there would be something very wrong with the way the whole decision letter had been structured, because up to paragraph 84,
yes,
up to paragraph 84, the tribunal made it very clear we're dealing with the cancellation assumption universe case. They get to 84, they say there's nothing here for us to trouble with further. 85 is the nib. The nib is, in more senses than one here, a connector. The nib is the connector to the no-scheme world, because the no-scheme world, very carefully defined in paragraph 55, what do we mean by a no-scheme world? We mean a scheme which gains an access from Buckley Hill Lane.
Yeah, but what's your answer? I mean, I'm sure you've said it, but I haven't got it in my head clearly enough. The proposition against you is that because the cancellation assumption is framed the way it is in the Act, that means that you cannot consider the no-scheme hypothesis when you come to assess the prospects of planning permission via Hope Value. That's what's said against you. Now, it's founded squarely on the terms of the cancellation assumption. What's wrong with it?
What's wrong with it is that it does not grapple with the realities of either the way in which the Act is structured or what the law tries to do, which is to fairly compensate. And the answer here is, if my lords took that approach, this landowner would be robbed of the value of his land in circumstances where he was able to, on the tribunal's finding, expect at some stage, have a reasonable prospect of a planning permission, on the back of someone saying, oh, but we're going to apply planning policies to you, which are scheme policies. And that's the whole point of the tribunal's assessment. Paragraphs 93 to 98 is to say, but if we're in a world in which we're going to respect a paragraph 55 world, how are we going to reflect that in a way which fairly gives value? The only way we can do it is to take a view about which elements of these policies, and that's the assessment of paragraph 94 and following, what weight should we give these policies to the extent that they are driven by the scheme? That's the quintessential.
So the proposition is that both the assumptions in 14 to 16, 14 to 17, and the disregard are both have the same overall objective, which is to give the landowner the value that his land would have but for the scheme.
Yes, the overall objective to fairly compensate him. And I realise I ought not to overwork it because of what happened in the House of Lords, but I have checked as to whether or not what my Lord Carnwath said in the Court of Appeal in Spires about the approach to the no-scheme rule and valuation and planning status was subject to contradiction, in other words, paragraph 24. And I don't think it was.
So which paragraph?
Paragraph 24 of your judgment in the Court of Appeal, you were handed it this morning.
I'm sure it wasn't. Can we just pick up paragraph 96? What's said against you, as I understand it, is in paragraph 96, the tribunal proceeded on a no-scheme world, the value on a no-scheme world, meaning no scheme either in relation to the reference land or in connection with the adjoining land. A, do you accept that's what they did in paragraph 96? And B, if so, do you accept they were wrong? I suspect I know what the answer to the second one is.
Well, it's the answer you would expect. The paragraph, I say with very great respect, seems to me to be not far short of pellucid.
No, I'm just asking you what you say it says, not how you say it says it.
Well, let me start from the fourth
No,
line.
just do you accept that it says that it's approaching it on the basis there's no scheme at all?
Yes.
Good. Right. And do you say it was wrong or right to do that?
Right.
Right.
Since otherwise, these landowners get robbed of the value.
And as a matter of statutory construction, with the two sections, I mean, it was put to was put to Mr. Humphreys that it was a combination of the two sections that means that you disregard the scheme both in relation to the reference land and in relation to the adjoining land, and you adopt that, do you?
Yeah.
Thank you.
Paragraph 93 here, if I may adopt an expression used by my Lord Sumption. Paragraph 93 is really the stand-back paragraph, isn't it? The tribunal standing back and saying, in this situation, in this situation, what is it? What development might there be which would produce an increased value? This is the point at which they stand back and say, and they then say, true to the paragraph 55, the second approach which they've identified as being an approach which, on the evidence they've got to consider, this is the only situation. And what follows from that is then a series of judgment and fact-finding exercises related both to the policy and the planning evidence that is being given, which then supports, I respectfully submit, amply supports the conclusion, which is ultimately reached. One may disagree with it, but it's a conclusion which, as an expert tribunal, they were best placed to reach and entitled to reach. A point was made about Melwood. May I say in relation to Melwood, I think from what I've read that Melwood was referred to in the speeches in both Spirose and Waters. It was referred to by the Court of Appeal here, I think in paragraph 37, or no, maybe 38. And I am unable to find anywhere where it has been suggested that Melwood should now be regarded as, in some way, unsound. If I'm incorrect in that, then no doubt your lordships will identify the place and it can be corrected. But it would be quite a startling proposition in the context of what your lordships have said earlier about not wishing to do anything which might upset the statutory processes which are seeking to straighten out some of what we've had to wrestle with for many years, for this court now to say that actually Melwood should be regarded as in some way unsound. I know of no basis and nothing that I should be drawing your attention to which indicates any court, whether Waters or Spirose or subsequently, has indicated that it's of doubtful assistance. I should observe also it was quoted in the tribunal case relied on by my learned friend Thomas Newell, and as I've said, referred to by the Court of Appeal here. My Lords, unless there are any other...
Could I just actually take you to that paragraph of my judgment in Spirose which you mentioned? Because,
Yes.
It may be of some relevance. This is, I mean, I've got it as a separate sheet. I don't know whether the Court of Appeal in Spirose.
Separately, I'm afraid it didn't get bound in.
And I was there referring to an argument that Mr. Barnes had made before the tribunal, that the no scheme rule had nothing to do with planning assumptions, it being a principle of valuation, not status. And that was an argument which he hadn't pursued in front of us, and I suspect didn't pursue in the House either. But it was based on some comments of Lord Denning and Myers, and of some of mine, apparently. But I say it's inconsistent with the reasoning of Lord Denning in the second Jelson case and with Melwood.
Yes.
I just wondered, I mean, Mr. Barnes has written quite an impressive book about compulsory purchase and compensation. No one's checked whether he is...
I've read it, or at least that's not quite accurate. I've read some of it. Being unable to contain the excitement of getting to the end. So I can only say that I haven't seen that position was being maintained, but I could not say that it's not.
Yeah, well, I can check the book for myself, but I just thought I'd just mention...
I may say that I have checked what your lordship said in Roberts, the case referred to here, that's the South Gloucestershire case. And Mr. Barnes was creative, shall I say, in taking what was a sentence in one context about the statutory structure and turning it into the submission he did. I've looked also at what I call Jelson 2, which is the Jelson being referred to here. I'm bound to say again, it seems to me to be
In a way, that's with you, because it's there, Lord Denning using the point Gord in relation to planning assumptions.
Absolutely, and an approach which, if I may say so, you appear to have endorsed, and Mr. Barnes appears to have, perhaps uncharacteristically, been willing to lay down.
Okay.
My Lords, unless there are any other matters that I can assist you with, I don't think there's anything else I wish to say.
On that naming observation, thank you very much indeed.
Thank you.
We are grateful to you both for your oral arguments and indeed to Mr. Kimlin. We will consider our decision and let you know in due course, and we'll have the benefit of the written cases as well, for which we're very grateful. Thank you very much indeed.